we are contacted with Justice Adarsh Kumar Goel in a while. Justice Adarsh Kumar Goel is joining in a while. Sir has joined. So we are starting with the live streaming now. नमस्कार, अधिवक्ता परिषद दिल्ली हाईकोर्ट यूनिट की तरफ से आज तीसरी राष्ट्रीय मूट कोर्ट प्रतियोगिता में मैं रिधिमा गौड़ आप सभी को नमन करती हूँ, वंदन करती हूँ, अभिनंदन करती हूँ. To judge today's final round, we have a panel of 3 eminent judges with us. We have Honorable Mr. Justice Adarsh Kumar Goel. We have Honorable Mr. Justice Rajendra Menon, sir. We have Honorable Mr. Justice C. Harish Shankar. Namaskar, sir. Before starting with the proceedings of the court, firstly, I would like to give a brief introduction of all the 3 judges. Justice Adarsh Kumar Goel was enrolled as an advocate with the Bar Council of Punjab and Haryana on July 16, 1974. Sir was also one of the founder members of Adhivakta Parishad. Having a practice of more than 2 decades, Sir was appointed as senior advocate by the Supreme Court on February 11, 1999. Sir was elevated as a judge of the Punjab and Haryana High Court on July 2, 2001. Sir was the acting Chief Justice of the Punjab and Haryana High Court till he joined as the senior most judge of the Guwahati High Court on September 12, 2011. Sworn in as the Chief Justice of Guwahati High Court on December 20, 2011, Sir sworn as the Chief Justice of the Orissa High Court on October 12, 2013. Sir was also elevated as the Judge of Supreme Court and assumed charge on July 7, 2014. Presently, Sir is appointed as the Chairperson of National Green Tribunal on July 6, 2018. We welcome you, sir. We also have with us Honorable Mr. Justice Rajendra Menon, sir. Justice Menon is an alumni of 1981 batch from NES Law College, Jabalpur. Sir started his legal professional career in the office of Senior Advocate P. Sadasivam Nair, after which Sir was appointed as Standing Counsel for Central Government in the year 1991. Sir was elevated as an additional judge to the Gwalior bench of Honorable Madhya Pradesh High Court on 1st April 2022. In 2008, Sir presided as a judge in Principal Bench, Jabalpur, of Honorable MP High Court, until his elevation as Chief Justice of Patna High Court on 15th March 2017. Sir was later transferred as a Chief Justice of Honorable High Court of Delhi on 9th August 2018 and served till 6th June 2019. We all were very fortunate to learn under the guidance and leadership of HMJ Rajendra Menon during his tenure as the Chief Justice of Delhi High Court. On recommendation of CJI, Justice Menon was appointed as a chairperson of Armed Force Tribunal on 6 November 2019, and Sir is currently presiding Honorable Armed Force Tribunal Principal Bench Delhi as chairperson. We welcome you, sir. We also have with us Honorable Mr. Justice C. Harish Shankar. Lordship did his LLB from CLC Delhi University in 1993. Sir appeared as arguing senior counsel before several judicial forums as well as Supreme Court of India and Delhi High Court. Sir was also empaneled as special panel counsel for the central government in Supreme Court of India, and Sir was also empaneled as a counsel for the Directorate General of Anti-Dumping. Sir was designated as senior advocate by the Honorable Delhi High Court on 20th August 2014. Sir was appointed as a permanent judge of the Honorable High Court of Delhi on 15th May 2017. We heartily welcome you all, sir. Now, to start with the proceedings of the court, I would request the courtmaster for the day, Shri Ayush Saxena ji, to please join and proceed.
Good afternoon, everyone. My name is Ayush Saxena. I am the court coordinator for today. I will recite the rules for the proceedings today. There are two teams, team 155 for the prosecution and team 107 for the defense. Both teams shall get 45 minutes to argue their sides. Each speaker can argue for maximum 30 minutes and can reserve 5 minutes for the rebuttal. With the permission of judges, do I have the permission to proceed with the court? Grateful, my lord. Speaker for the prosecution, may please begin.
Much obliged. Your lordships, I request permission to address the bench collectively as your lordships.
Yes.
Much obliged. Your lordships, I will be taking 20 minutes of this honorable court's time, and my co-counsel would take 23 minutes of this honorable court's time. Your lordships, I request the court's permission to allow screen sharing to highlight important aspects of the present matter. I request the court master to grant permission for screen share.
You may please proceed.
Indeed, your lordships. Your lordships, if it may please the court, the counsel seeks permission to state the facts of the case in brief.
Yes, you can proceed, and
Much obliged.
there is no need to seek so many permission. You can go ahead. Yes.
Indeed, your lordships. Miss Kajal, the complainant in the FIR, heard screams of a girl from a vacant plot outside her home and went with her husband to the spot. They saw one individual holding a gun and three others sexually assaulting a girl. Upon seeing some resident coming towards them, the accused fired a shot towards the residents and fled from the spot, leaving the girl there. The victim was lying unconscious and couldn't speak. She was taken to the hospital and a call to 100 was made. The complainant helped in admitting the victim in DDO hospital. Medical examination of the victim confirmed rape and sexual assault on her. Once she regained consciousness, her statements under Section 161 and Section 164 of the CRPC were recorded by the Honorable Metropolitan Magistrate. On 15 February 2022, Rakesh, one of the four accused, was arrested through information given by a secret informant. Being cooperative to the investigation, he confessed that he, along with three others, Anuj Kumar, Anil Kumar, and Ajay Kumar, kidnapped the victim and all of them raped her. During further inquiry, he confessed that he knew the hideout of the other three accused and the police caught the three accused from this hideout in Vikaspuri. Three accused were remanded in judicial custody and the fourth accused, Rakesh, was deemed to be mentally fit to be tried as an adult after an assessment under Section 15 of the Juvenile Justice Act 2015. With the permission of the bench, the counsel for the further prosecution would like to begin the pleadings.
You will not ask permission every time. Once you are given permission once, that is a permission to complete your whatever you want.
Indeed, your lordships. I apologize. I shall be addressing the first and third issue at hand, that is, whether charges can be framed against the accused of the offences under Section 361 and 363 of the Indian Penal Code, read with Section 34 and 120B of the Indian Penal Code. Whether charges can be framed against the accused for offences under Section 25 and 27 of the Arms Act. The council humbly submits before the Honorable Sessions Court that the accused are charges can be framed against the accused under Section 361 and 363 of the IPC by way of threefold argument. Firstly, I submit before this court that it can be established from the facts that the four accused kidnapped Manisha and enough evidence exists to justify framing of charges against the accused. Secondly, the council shall explain the fact that the four accused had common intention for doing the criminal activity. Thirdly, I plead before this court that criminal conspiracy was formed between the four accused. Your Lordship, the fact sheet lists various aspects which indicate a kidnapping. All the four accused use Pulsar and Splendor bikes to kidnap Manisha and rape her. This has been mentioned in page 11 of the prosecution's charge sheet in the last line. Page 18, which states the prosecutory statement also confirms the use of the gun and the later hiding of it. Page 33, line 15 to 17 of the prosecution's charge sheet also states the victim's statement that she was kidnapped this statement was recorded under section 164 of the CRPC. Your Lordship, apart from the claims in the charge sheet, there also exists circumstantial evidence which justifies the kidnapping charge. Your Lordships, the victim prosecutrix was going to school and she was kidnapped from there. The whereabouts of the child were unknown till she was found at the crime scene. She was recovered from the crime scene in the custody of the four accused. Your Lordships, I now rely upon section 361 of the Indian Penal Code. According to this section, whoever takes or entices any minor under 16 years of age if a male or under 18 years of age if a female out of the keeping of the lawful guardian of such person without the consent is said to kidnap such minor or person. Your Lordships, in the case S. Varadarajan versus State of Madras, the court held that if a minor is taken away from the lawful guardian without the consent, it is considered that a kidnapping has taken place. Your Lordships, I now humbly submit that at this stage of proceedings, even a very strong suspicion founded upon materials before the magistrate or the sessions court judge, which leads him to form a presumptive opinion as to the existence of the factual ingredients constituting the offense alleged, can justify the framing of the charge. This was held by the Honorable Supreme Court in the case of State of Bihar versus Rajesh Singh. Your Lordships, I humbly submit that this principle is applicable in the current matter before this Honorable Court as well. There exist sufficient claims and evidence to justify the framing of a charge under these sections against the accused. Your Lordships, I now submit that criminal conspiracy was formed between the four accused. I urge your Lordships to refer to section 120A of the Indian Penal Code 1860. From an understanding of the bare text of this section, it is clear that when two or more persons agree to do an illegal act or an act which is not illegal by illegal means, such an agreement is designated as criminal conspiracy. The Honorable Supreme Court held in the case of Kehar Singh and others versus State that evidence in form of a direct witness is enough to convict the accused under this charge of criminal conspiracy. Your Lordships, I humbly submit that the accused person's conduct is a situation where criminal conspiracy has taken place as defined in the law. Your Lordships, in Pratap Bhai Hamir Bhai Solanki versus State of Gujarat, the Honorable Supreme Court held that criminal conspiracy may be proved by either direct or circumstantial evidence. And since direct evidence is rarely available, circumstances before, during, and after the occurrence of illegal activity must be considered. Your Lordships, I humbly submit that there exists a lot of circumstantial evidence against the accused in the present matter. Their escape from the crime spot upon seeing the witnesses, the way they were found by the witnesses with the victim in a compromising position are enough grounds to justify the framing of a charge in this present matter. Your Lordships, the view of lack of direct evidence being present was reiterated in the case of Mukesh and others versus State for NCT of Delhi and others, where Justice Jagannath Shetty stated that a conspiracy from its very nature is generally hatched in secret. It is therefore extremely rare that direct evidence is available by determining a charge under criminal conspiracy. But like other offenses, this charge may be proved by circumstantial evidence. Therefore, it is humbly submitted before this Honorable Court that charges can be framed against the accused on grounds of criminal conspiracy. Your Lordships, I now would like to bring your kind attention to section 34 of the Indian Penal Code, which defines common intention as the following. When a criminal act is done by several persons in furtherance of the common intention of all, each of such persons is liable for that act in the same manner as if it were done by him alone. Your Lordships, the Honorable Supreme Court held in the case of Devilal versus State of Rajasthan that common intention for the establishment of common intention, each accused must be aware of and embrace the objective of the others. Your Lordships, I humbly submit that the objective of the four accused was very clear from the circumstances provided, that is, to kidnap and rape Manisha. I humbly submit that the existence of common intention is determined from the acts of the accused, and when the acts are done with an object of performing a crime in question, common intention is applicable. It is therefore humbly submitted that charges can be framed against the accused under Section 361 and Section 363 of the Indian Penal Code, read with Section 34 and 120B of the Indian Penal Code. If it pleases your Lordship, I would like to begin my arguments on framing of charges under Section 25 and 27 of the Arms Act. Much
Are you
obliged.
waiting every time and unnecessarily asking when you are told that you can proceed?
Much obliged, your Lordships. The Council would like to describe Section 25 and 27 in brief. Section 25 punishes any individual who uses, sells, or manufactures any weapon or ammunition without obtaining a license. The punishment for this offense is a minimum jail term of 3 years with a maximum sentence of 7 years. Section 27 penalizes the use of unlicensed arms in particular, and the punishment is the same as the punishment in Section 25. Your Lordships, I humbly submit that a charge can be framed against the accused based on strong suspicion founded upon materials before the Sessions Court judge, which leads him or her to form a presumptive opinion as to the existence of the factual ingredients constituting the offense. This was held by a three-judge bench of the Supreme Court in the case of Superintendent and Remembrancer Legal Affairs versus Anil Kumar Bhunja. This case dealt with charges framed under illegal possession of an arm. Your Lordships, I urge you to note the following facts which justify the charge of Section 25 and 27 of the Arms Act. Page 41, the bullet being a part of ammunition as defined in the Arms Act. These were a results of the examination and the FSL reported conducted by the investigation. Your Lordship, the essential ingredients of these sections have been defined in the case of Gunwant Lal versus State of MP. According to this case, the first ingredient of convicting an individual under this law is intention and the knowledge with which the person possessed the firearm. The Lordships, constructive possession of the gun, according to which an individual has power and control over the gun, is also necessary. It is humbly submitted that all these essentials are fulfilled in the present case. The two accused, Rakesh and Ajay Kumar, are liable under this section due to the clear presence of intent to use the gun to escape it by firing in the air. The recovery of the gun after the arrest took place shows the fact that the accused had constructive possession of the gun. I request the Honorable Court to refer to page 9, line 2 of the proposition, which states that the accused fired a shot in the air to help their escape. Your Lordship, I humbly submit that direct evidence exists to prove the use of the gun for an antisocial purpose. The witness statements and the recovery of the gun from the accused are direct evidences confirming the same. I would place arguments now with regard to the liability of the other two accused, Anuj and Anil Kumar, in this present case. Section 34 of the Indian Penal Code will be applicable here to prove the common intention of the other two accused in committing the offense under the Arms Act. Your Lordships, in the case of Indrapal Singh versus State of UP, the Honorable Supreme Court held that for common intention to be proven, there must exist either direct proof of prior consent or in cases where direct proof is absent, there exists proof of circumstances which lead to the inference of guilt. The circumstances in question must also be incapable to be explained away in a reasonable manner if the accused is to be acquitted in the present situation. Your Lordship, it is humbly submitted that while there was no direct use of arms or possession by the remaining two accused, the circumstances of the weapon seizure and their acts at the crime scene clearly show their intent in helping the two other accused use the weapon to escape, and the seizure of the weapon from their common hideout also showcase their intention to conceal the weapon. Your Lordships, I would like to place an analogy before this Honorable Court, which was cited by the Supreme Court in the judgment of Jasdeep Singh versus State of Punjab. The Supreme Court made an analogy comparing a crime committed by a group of individuals to a football team, where each member of a team has a different role and performs different tasks, but they work towards a common objective. This analogy was also described in the case of Suresh versus State of UP, where it was observed that even if no direct act is done by an accused to help in the crime's commission, he may be held vicariously liable if he omitted to perform an act which would have helped prevent any crime. On application of these precedents, it is humbly submitted that charges can be framed against the remaining two accused, Anuj and Anil Kumar, under Section 25 and 27 of the Arms Act due to their overall participation in the crime, and they failed to do any act which would have prevented the crime. If your lordships are satisfied with my arguments, I invite my co-counsel to begin her pleadings on the second issue at hand before this honorable court, of the present matter at hand before this honorable court.
But Mr. Counsel, how can name of the victim be disclosed?
Your lordships, the name of the we understand that the name of the victim is to be is your lordships. I believe that that law refers to the name of the prosecutrix in the media. There no disclosure in media has taken place in this present matter, and the
Even in court proceedings, it can't be disclosed. Even in the charge sheet, it can't be disclosed.
I apologize, your lordships.
Will
It
it
has
constitute an offense under Section 228A IPC against the person disclosing the name?
your lordships. I apologize for the same. The name of the
No,
prosecutrix has
question is
been
not apology. Question is offense is committed by disclosure. And offense provides for 2-year sentence. Then how are you relying on confession in police custody?
Your lordships, we are not relying primarily upon police custody. There exists other evidences, the circumstantial evidence, the escape of the from the crime scene, their being together with the victim in a compromising position justifies the same.
Justice Menon is there.
Yes, Mr. Counsel, you have charged them under Section 34. Now,
Indeed, your lord.
one of the ingredients necessary for Section 34 is prior meeting of the minds. Now, the circumstantial evidence only shows their presence at that place. But where is the prior meeting of the minds in the statement? Even in the confession statement of Rakesh Kumar, it is not there.
Indeed, your lordships. Your lordships, your lordships, I have cited a case here. I will reiterate that case
Yes.
here.
Yes.
Indeed, your lordships, I will cite that case. Your lordships, Indrapal Singh versus State of UP. Your lordships,
Yes.
there it is not necessary that even direct proof or the witness directly confesses to their involvement of a common intention or prior meeting of mind. Your lordships, the acts of the accused and the circumstantial evidence of the weapon seizure justify their charge, the common intention. Your lordships, if all the 4 accused are present at the crime scene and escape together, your lordships, I humbly submit before this honorable court that a framing of charges is at least justified. While trial procedure may require a stricter standard of proof, framing of charges, your lordships, I submit that it requires a lesser standard of proof in this present matter.
You see, according to the statement of the prosecutrix itself, she knows all the 4 of them. They live in the same locality. So can their presence in the same place coincidentally be derived from them? Can it not be a defense by them? And under those circumstances, prior meeting of minds to do the offense, is it not necessary?
Your lordships, while prior meeting of minds is an important element to determine common intention, your lordships,
Yes.
I would humbly submit in the case of Suresh versus State of UP that it was observed that even if no direct act is done by an accused by any accused person to help in the crimes commission, your lordships, he may be held liable in this case if he omitted to do any act which would have helped prevent the crime. Your lordships, none of the accused have done anything to prevent any crime. They were all participating in the crime together, and as soon as witnesses saw the victim with the accused, they escaped from the scene. Your lordships, I humbly submit that innocent persons would not escape if they saw a group coming towards them. It is my submission.
Okay. Yes, brother Hari Shankar, you have any queries? Brother Hari Shankar?
Yes, I'm sorry, my mic was muted. Yes, just to continue from what Justice Menon asked. According to you, is there any legal difference in law, especially in the context of 34, between common intention and prior meeting of minds? Because you referred just now to their running away from the spot. Now, running away from the spot case, obviously something which happens after the act has been committed. Right. Now, in the context of 34, because it is a serious charge. So, is there a difference jurisprudentially between these two? Or do you have any decision which either says that they are the same or that they are different?
Your Lordships, while there does exist a difference between common intention and mere meeting of minds, Your Lordships, I submit that the circumstances provided. I refer to the running away just to point out just to bring it to the attention of the Honorable Court that the accused cannot be presumed innocent in this matter. Your Lordships, with reference to common intention, the circumstantial evidence is often yes.
All right.
Your Lordships, I would just like to complete my
Yes, certainly.
Yes, Your Lordships, I am trying to plead before this Honorable Court that while common intention and mere meeting of minds does not equate to a common intention form a crime, Your Lordships, I submit that the circumstantial evidence, the escape of the accused, and the fact that they kidnapped the victim from a spot while she was going to the school all point towards the fact that they have a common intention to perform the crime. Their hiding of the gun is also, I submit, an important point due to the fact that if they were innocent, they would not have done anything to prevent the police from finding anything that will incriminate them. I humbly submit this.
No, I just want to know, have you examined this point of whether, because there are actually, I find there are the Supreme Court judgments on this point of within the context of 34, is common intent enough? Does it amount to prior meeting of minds? Or is there actually a difference between the two in the context of 34?
Your Lordships, from my understanding of the law, I understand that meeting of the minds is a thing that leads to common intention. Once the accused have agreed to do something, they then develop an intention to perform the crime. And I submit that upon circumstantial evidence, upon the analysis of evidence, it is evident that the accused are having an intention to perform the alleged crimes in this present matter. That is my submission before this court.
Thank you.
Much obliged, Your Lordships. I seek permission to invite my co-counsel to begin her arguments.
Good evening to the bench. The co-counsel for the prosecution shall be addressing the second issue that has been brought up before this honorable court. With the permission of the bench, the co-counsel for the prosecution would like to humbly submit its pleadings. I shall be addressing the second issue at hand, that is the 4 accused has committed the rape of the prosecutrix. The counsel shall humbly submit before the honorable court by a way of threefold arguments. Firstly, I shall appraise this court that there were enough medical evidences to support the statement of the prosecutrix. Moreover, conviction can be made on the sole statement of the prosecutrix, provided that it has no material discrepancies. Secondly, I will explain that the statements made by the accused in the police custody were admissible as evidence in the court of law as per Section 27 and Section 30 of the Indian Evidence Act. Thirdly, there were no material differences in the statement of prosecutrix given under Section 161 and Section 164 of CRPC. It is most humbly submitted before this honorable court that there were enough medical evidences along with other evidences to support the case that the accused committed the rape of the prosecutrix. Your Lordship, the co-counsel will now first establish that there is no need to discard the statement of prosecutrix if no evidence is against it. Your Lordship, it is imperative to bring to your light that the statement made by the accused in such a gruesome case becomes the Bible for the court, and the evidence of a victim of sexual assault stands almost at par with the evidence of an injured witness, and to an extent is even more reliable. In cases involving sexual molestation, consideration and allegations which have meager effect on the veracity of the prosecution case and on the statement given by the prosecutrix should not, unless the discrepancies are such which are of fatal nature, be allowed to throw out. Your Lordships, in the case of HP versus Raghubir Singh, the apex court of a country has acknowledged acceptance of the statement to be true as if it inspires confidence and there is absence of circumstances which militate against her veracity. The testimony of the victim in such cases is vital, and unless there are compelling reasons which necessitate looking for the corroboration of a statement, the court should find no difficulty to act on the testimony of a victim of sexual assault alone to convict the accused, where her testimony inspires confidence and is found to be reliable. Seeking corroboration of a statement before relying upon the same, as a rule, in such cases amounts to adding insult to the injury. And your Lordship, in our case, this 15-year-old has to go through a lot of social demeanor, which is hidden under the garb of this case and shall unveil as and when the proceedings of the case progress. So it would not be in the right mind to cause her more mental agony by discarding her statement. Now, for medical evidences, Your Lordship, I would like you to refer page number 35 of the Moot proposition, which is the MLR of the prosecutrix. Your Lordship, in this MLR signed by senior gynecologist Dr. Hemlata, it has been clearly mentioned that the hymen of the prosecutrix was torn and there has been abrasion of breast of 3 centimeters, shows that there was sexual intercourse. Also, Your Lordship, I would like you to refer to page number 9 of the Moot proposition, in which brief facts of the case are provided. Your Lordship, on 7 and 8th line, which mentioned that the prosecutrix was bleeding from her private parts, all these evidences are clear enough to prove that she was raped, and her statement has been supported by these evidences. Now, the co-counsel would be establishing that the accused can be convicted on the basis of the statement only. Your Lordships, in the case of State of Karnataka versus S. Raju, the Karnataka High Court upheld that even in the case of absence of medical evidence, rape accused can be convicted. Therefore, the corroboration with the medical reports is not necessary in every case. Corroboration as a condition for judicial reliance on the testimony of the prosecutrix is not a requirement of law, but a guidance of prudence under the given circumstances. This is a very similar case, Your Lordship, as the facts are very alike. A 14-year-old girl was raped on her way to home brutally, and it was very evident by the marks and the assault done and the statement which she gave to the court confidence to pass a verdict against the accused persons. Although in our case, there is material evidence as the hymen was torn and the evidence of injuries on the private part, and I shall establish in the forthcoming arguments that the 4 accused are liable under section 376DA of Indian Penal Code, section 6 and section 8 of the Protection of Children from Sexual Offences Act. But from the arguments made just, the co-counsel asserts that the statements of eyewitnesses, prosecutrix, along with other medical examination report of the prosecutrix, which specify that the hymen has been torn and there has been abrasion of breast of 3 centimeters is enough evidence to make the 4 accused liable. If the court is pleased with the co-counsel's first limb of the argument that there were enough medical evidences to make the accused liable and statements of the prosecutor is in good faith and there is material evidence. Okay, there are a lot of people. And there is material evidences that is enough to make the accused liable, the counsel would seek permission to move on to the next limb.
Please, Madam, go on.
Madam, one of the accused is minor.
Yes, Your Lordship.
How do you proceed against the minor, number 1? Number 2, according to you, this confessional statement, how it is admissible under section 27 of the Evidence Act?
Yes, indeed, Your Lordship. Your Lordship, the statements given by the accused is admissible in the court of law because it has been given voluntarily by the accused.
No, it is not given in court of law. It is given to the police.
Yes, Your Lordship, I agree that it has been given in the police custody, but section 27 of the Indian Evidence Act states that if the confession is being made in a voluntary manner, it shall be admissible.
No, it doesn't.
No.
It doesn't
Madam,
say.
read the provision.
Yes, Your Honor. Yes.
27 has a very distinct application.
Your Lordships, I seek permission to interject here. May I?
Whatever you decide among yourselves.
Indeed, much obliged, Your Lordships. Your Lordship, Section 27 of the Evidence Act states that when accused makes a confession in police custody, Section 25 provides a general blanket ban on these confessions, but Section 27 creates an exception and says that if the confession leads to the discovery of a fact which is distinctly connected to the alleged offense, it may be proven. Your Lordships, that is why we have
So what
relied
may be
upon.
proved? Only the information about discovery, that's all. Not anything.
Your Lordship,
not
I
anything else.
apologize. Could you rephrase the question slightly? I am unable to hear.
No, what is admissible is only that part that there is a discovery.
Indeed, Your Lordships.
No, not anything else, not the rest of it.
Your Lordships, I submit
So much
that.
of information, only that much of information.
Indeed, Your Lordships. Your
As
Lordships.
relates to discovery.
See, for example, if a weapon is discovered, you don't know that there is a weapon. A weapon
Only
is
weapon
discovered.
is
as a
discovered,
consequence.
that's all.
To
This is
that
only
extent,
admissible.
that's all you can rely on. You can't rely it as a substantive evidence of the offense.
Your
Or as a
Lordships, Your Lordships, I apologize. Please
So
continue.
it doesn't dilute from 161 or it doesn't take away the dilute from 162.
Your Lordships, I cited 27 as an exception to 25 here because the fact discovered in this present case is, I submit, is the charges or is the fact that the victim's hymen was torn and the medical examination confirmed that rape and sexual assault took place. We are connecting this statement, this confession by the accused with that discovery of fact, Your Lordships. That is my submission before this honorable court.
So discovery is something which is not known. The weapon is known, other things are known. So nothing is admissible here.
And the victim's hymen torn has come out of medical examination. It is not in the statement of
something which is not known. If that becomes known only to that extent.
Your Lordships, I submit that the discovery of the fact term is a subjective, and I submit that it does link, the accused confession does link to the present matter at hand. That is my submission.
All right, is that all?
Your Lordships, my co-counsel would proceed further.
Yes, Madam, where is she?
I think, I apologize, Your Lordships. There was a power cut. I think she will rejoin in 2 minutes.
Am I audible?
Yes.
Yes, Madam.
Your Lordship, it is most humbly submitted for this honorable court that the statements made by the accused will be admissible in the court of law. The statements made by the accused are admissible in evidence and are following the procedure laid down in the Evidence Act of 1872. Section 27 of the legislation allows the police to use these statements as evidence against the accused. The Supreme Court in the case of State of City of Delhi versus Navjot Sandhu has described the application of Section 27 of the Evidence Act in detail. Your Honor, now I shall explain the court the various conditions that have to be fulfilled.
What is the fact discovered? What is the fact discovered by the statement?
Your Lordship, the new fact that was told by accused number 1 about the modus operandi of the crime they committed, and he told us
that is not a discovery. What is discovery has a legal meaning? What is discovered?
The accused told the police officers the address of the probable.
Then the entire confession is admissible. Then 25 has no meaning.
Your Lordship, the confession and the fact that he told was in voluntary manner, so it can be admissible
No, is according to you voluntary confession admissible?
Yes, Your Lordship.
It's not. What you are saying is against section 25.
Your Lordship, in the section 27, it has been mentioned that if the accused gives statement or confession
So
voluntarily.
therefore 25 will be ignored.
Your Lordship, it depends on the discretion of the arrested person whether he wants to give confession or not. It is not a pressure on the part of accused to give statements or confession. But if he wishes to, he can give, and it would be admissible in the court of law.
Even if it is in police custody.
In the police custody as well as in the, he can give, and he can also give confession to in front of a magistrate also.
Has he made before the magistrate? He has made only in police custody.
As of now, the accused hasn't made any confession in front of the magistrate.
Therefore, whatever he has made before police, that is not admissible. That will have to be ignored.
Your Lordship, it cannot be ignored because it has been given to the police officer, and believing that state would not, it has been written in the Moot proposition that the accused gave the confessions and statements voluntarily. So
Please show that from section 25 of the Evidence Act that voluntary confession is admissible.
Yes, Your Lordship, voluntarily confessions are admissible, and in the present case.
Please show from section 25. Anyway, that is your point. We will see. You can read section 25 if you like.
Yes, Your Lordship. Section 25 of the Indian Evidence Act, confession to police officer not to be proved. No confession made to a police officer.
It is not admissible at all. It can't be proved at all, whether voluntary, whether involuntary, whatever. No confession made to police officer can be proved in court.
Your Lordships, I apologize, but I seek permission to interject here again.
But you have been given opportunity. Why again and again?
I apologize.
Same question is being asked.
I apologize, Your Lordship.
Your Lordship, I would like to state that in section 27, the accused has the right to give confession if he wants to voluntarily. So applying the section 27, the accused have told police officers many new discovered facts. So applying section 27 would be through which the confession can be admissible.
Anyway, that is your argument. That's all. Is your time over or still there?
Your Lordship, I have to still makes few arguments.
But have you taken sufficient time? What is allotted to you?
No, Your Lordship. I have still left with some time.
Okay, then complete your time.
Indeed, Your Lordship. Your Lordship, there has been a discovery of a new fact through the information received by the accused. This information received must also be obtained without any coercion or undue influence, which is in the present case. And it is humbly submitted before this court that the condition has been followed in the present case. Your Lordship, here I would like you to refer to page number 10 and 11 of the Moot proposition, in which brief facts of the case has been mentioned. Your Lordship, it has been written that when the accused person were taken in the police custody, they voluntarily revealed information about the way they committed the crime. And they gave new information about how they kidnapped the victim from her school van and how they ran away after raping her upon hearing the voices of the witnesses. Your Lordship, even the second requirement is that the information must be distinctly connected to the fact that needs to be proved. The phrase distinctly refers to the fact thereby discovered is the key phrase in the statute that and must be interpreted correctly to determine the usage of any statement as evidence. It is humbly submitted that this requirement of law has been fulfilled. Your Lordship, if we refer to page number 11, it has been clearly mentioned that the information directly led to an understanding about the modus operandi of the accused. It was analyzed directly. The statement of the accused is admissible in this court by virtue of section 30 of the Indian Evidence Act also. This was made clear by the Honorable Supreme Court's judgment in the case of Hari Charan Kurmi versus State of Bihar. Section 30 is applicable in the present situation due to the fact that other evidences are satisfactory in nature to make the accused confession justified. Many pieces of evidences are cited to support the prosecution's argument with regards to the guilt of accused. The statements of witnesses Kajal and Satyajit Kumar describing the crime are very important. Section 3 subclause 1 of the Indian Evidence Act 1872 relates to the eyewitnesses' testimonies and attaches major evidentiary values to the statements made by an eyewitness under oath. They are admissible in India and here in the present case.
No, they are not admissible to police. Confession made to police is not admissible.
Your Lordship, can you please repeat your question?
Confession to police is not admissible.
Yes, Your Lordship. But in the present case, the witnesses gave the statements about the crime, how the crime happened. So the
all right. So I think if Justice Menon and Justice Harishankar have any questions, I think the time is already 45 minutes are over given to you. But any questions?
No questions from me.
So
No questions, sir. No questions.
Then I think it is 45 minutes are over. Can we go to the next team?
Your Lordship, can I seek an extension of 2 minutes time to sum up my arguments?
Oh, all right.
Thank you, Lordship. Your Lordship, Supreme Court in the case of my third sub-issue is that there are no material differences in the statement of prosecutors under section 161 and section 164 of CRPC. And moreover, slight changes in the statements doesn't completely mean that the statements are falsified. In the Supreme Court case of State of Punjab versus Gurmeet Singh, the Supreme Court has opined and emphasized with the viewpoint of handling the victim statement with care and giving it utmost importance in a rape case. Also, the Supreme Court has stated in this case only that the evidence of victim of sexual assault is enough for conviction and it does not require any corroboration unless there are compelling reasons for seeking corroboration. The court may look for some assurance of a statement to satisfy the judicial concerns. If for some of the reason the court finds it difficult to place implicit reliance on her testimony, the testimony of the prosecutors must be appreciated in the background of the entire case and the trial court must be alive to its responsibility. Here, Your Honor, the statements given under section 161 and section 164 implies that the 4 accused kidnapped her and raped her, which is very true with regard to the other evidences collected by the police. So immaterial changes in the statement of prosecutors would not have any impact. Thus, the law that emerges on the issue is to the effect that the statement of the prosecutors, if found to be worthy of reliance, requires no corroboration. The court may convict the accused on the sole testimony of the prosecutors. Now, Your Lordship, I would like to recite the prayer. Wherefore, in the lights of the issues raised, arguments advanced, and authorities cited, it is humbly submitted that the Honorable Court may be pleased to charge the 4 accused guilty for the offences of kidnapping and criminal conspiracy in committing the alleged crimes. Second, charge the 4 accused guilty for the offences of gang rape and sexual assault of prosecutors as they have been charged for the same by the state. Third, charge the 4 accused guilty for the offences of sale or illegal use of arms and ammunition as defined in the Arms Act 1959 and pass any order, direction, or relief that this Honorable Court may deem fit in the interest of justice, equity, and good conscience. It was a pleasure pleading before this court.
You did not answer the question that the accused is minor. How can he be charged?
Your Lordship, one of the accused was minor, but when he was sent to the rehabilitation center and the board conducted his assessment, that board came to a conclusion that he had the physical and mental capacity. So he should be tried jointly with the other 3 accused.
So we now go to the next thing.
Yes.
Counsel seeks permission to address the bench.
Yes, you are called upon, no need of permission. You are called upon, you have to do it, you have to proceed. You have been asked to proceed.
Much obliged, Your Lordship. Counsel shall address this court as Lordship individually and collectively as Your Lordships. Your Lordships, I, along with my co-counsel, will be representing the accused persons in the matter of State versus Rakesh Kumar and others. Counsel will be dealing with charges relating to the Indian Penal Code and the Arms Act and will be taking up 18 minutes, while my co-counsel will be dealing with charges relating to the JJ Act and the POCSO Act and will take 19 minutes. We'll be reserving 8 minutes for rebuttals. If the Lordships are satisfied with the facts of the case, counsel will proceed with the body of the argument.
No question of satisfaction, we have read it. We have read the facts, we know the facts.
Please proceed, madam.
Proceed.
Proceed in the manner you want.
Much obliged, Your Lordships. Counsel will proceed with the first issue of charges under the Indian Penal Code. This issue will be divided into 4 limbs. Moving on to the first limb of section 376DA. According to the Indian Penal Code, a man is said to have committed rape when he penetrates his penis, inserts an object or applies his mouth to the vagina, mouth, urethra or anus of a woman, or manipulates any part of the body of women so as to cause penetration. Your Lordships, in the present case, there are many instances to prove that rape was not conducted against the victim. The medico-legal certificate in the present case is insufficient to prove rape.
No, you are talking of evidence at this stage. It's only a stage of charge. It's not a stage of appreciating the evidence or convicting or acquitting. It's only a stage of charge. Is there any material? That's all. Charge stage only requires to see is there any allegation. If proved, it will make an offense.
Yes, Your Lordship.
Counsel understand the scope of consideration at charge.
Yes, Your Lordship. Counsel will keep that in mind. Your Lordship, the prosecution here has used the medico-legal certificate to prove that rape has been committed against the prosecutor in the present matter. However, there is no mention of injuries that could indicate that penetration into vagina, anus, or mouth has occurred.
Is it required? Injury is required.
Could you repeat that, Your Lordship?
Is the injury required under any law?
Your Lordship, however, the section of rape under the Indian Penal Code states that the penetration or manipulation of any body part of the women will lead to rape, and this could indicate or could show the presence of an injury, especially when it comes to non-consensual sexual intercourse. Your Lordship.
Injury is not required.
Yes, Your Lordship. If the counsel.
Injury is not required. Number one, the statement of prosecutor itself can be accepted. No corroboration of medical evidence is required if there was an injury or there was penetration.
Yes, Your
Statement
Lordship.
of the prosecutor and even the statement of the eyewitnesses who said they saw her in the compromising position.
Yes, Your Lordship. Counsel will be addressing this particular manner in the upcoming argument.
Yes, please go ahead.
Yes, Your Lordship. The prosecution has mentioned the tear of the vagina. However, in the case of State versus Lalit Rataval, mentioned in page 13 of the memorial, it was acknowledged that the hymen could be torn due to several reasons.
No,
And
maybe,
in fact,
maybe it is possible to be torn for other reason. Doesn't mean it is not for the in the manner alleged. Number one. Number two, it's not a stage of appreciation of evidence. It's a stage of charge.
yes, Your Lordship.
Even a strong suspicion or material or allegation is enough for the charge stage.
Yes, Your Lordship. Counsel proceed to the arguments regarding the medical examination of the accused persons in the present case. According to section 53 of the Code of Criminal Procedure, it makes medical examination of the accused persons a mandatory provision. However,
it is not mandatory, number one. Number two, if it is not there, it doesn't mean he is to be discharged. Only because he has committed rape, he was not medically examined, therefore he should be discharged. Can it be said?
Yes, Your Lordship. It does not throw away the prosecution case. However, in the present matter, a medical examination of the accused persons is necessary to refute a false charge of rape, which is why
it can't refute. It can't refute. Whatever be the medical evidence of the accused, it is only for his protection that the police has not tortured him. What is his mental status or physical status is recorded. That's all. It has nothing to do with the charge. On that, the charge can't be, you can't be discharged on that ground.
Your Lordship,
any judgment where any person has ever been discharged on that ground.
Your Lordship, however, since this is a rape case and section 53A of the CRPC talks about
any judgment of any court that a person is discharged because under 53A he was not medically examined. Only on that ground.
Your Lordship, the council does not have a case law proving the same.
Well.
Much obliged, Your Lordship. Council will proceed to the next set of arguments. Your Lordship, it is to be noted in the present case that the medico-legal report submitted before the Honorable Bench alleging rape of the prosecutrix is not reliable in the present case. According to the FIR, the victim was sent
to a stage of reliability today at the charge stage.
However, Your Lordship,
is reliable to be determined at the charge stage.
However, Your Lordship, in the present matter, the contradiction of the medico-legal report that here is used by the prosecution to frame a charge
Can
against.
Such contradiction be ground for discharging? The question today is whether the charge is to be framed or accused is to be discharged.
Yes,
now,
Your Lordship.
Is it your case that a case is made out for discharge?
Your Lordship,
argue that point which can result in your discharge.
Much obliged, Your Lordship.
And support your argument with any law.
Yes, Your Lordship.
Statute, law, or judgment.
Much obliged, Your Lordship. Moving on to the next set of argument regarding the same charge. The witness statements and the testimony of the prosecutrix in the present case are unreliable. Your Lordships, in her statement
to be determined, again, the same question. At the charge, please understand the difference of the charge stage and the trial stage. Is at the charge stage, can accused be discharged by saying evidence is not reliable or etc., or there is a contradiction or medical evidence is not adequate, etc. Please write any law on the point. What is the consideration at this stage of charge?
Your Lordship, if you could provide counsel with a few minutes.
Yes, enough opportunity. Only question is, please focus on the relevant point.
Yes, Your Lordship.
It's legally permissible. If it is, then support it.
Yes, Your Lordship.
Or you can go on in your own way. The question, the idea of asking question was to make you focus on that point.
Yes, Your Lordship. If you could provide counsel with a few seconds to get back to the argument.
There is no problem of seconds. Problem is of the point, of the direction of your argument.
Yes, Your Lordship.
You can go on. If you are getting disturbed, you can go on.
Yes, Your Lordship. Council would like to proceed with the argument, and we'll get back to this point soon.
You can proceed the manner you want.
Much obliged, Your Lordship. Your Lordship, in the present case, the prosecutrix has stated that she was in her statement to the police, she has stated that she was kidnapped by the accused persons on gunpoint on 2 motorbikes. However, in her statement before the magistrate, she stated that she was forcefully taken to a vacant street by Rakesh Kumar, where 3 other men were standing. Both her statements are contradictory in the present matter, Your Lordships. She also stated that Rakesh Kumar was pointing a gun to her forehead. However, Rakesh Kumar's fingerprints were not discovered on the weapon. Your Lordship, in the case of Raju,
fingerprints are required.
Could you repeat the question, Your Lordship?
Why fingerprints are required to be discovered?
The fingerprints on the weapon could create a case against the accused person here for possession.
Even without that, case will be there.
Your Lordship, it is not.
You know the difference in direct evidence and circumstantial evidence. When there is no direct evidence, then these questions arise.
Yes, Your Lordship. However, the defense counsel would just like to bring doubt into the mind of the honorable bench regarding the charges that have been put forward by the prosecution.
If doubt is created, then charge has to be framed. You have to remove the doubts.
Yes, Your Lordship.
There is no case. You have to establish there is no case.
Yes, Your Lordship.
For discharge, you have to establish there is no case, no possibility of any conviction. No material for conviction.
Yes, Your Lordship. In the present matter, counsel would like to bring forward the case of Raju versus State of Madhya Pradesh.
Is that on charge? Is that on charge?
Yes, Your Lordship. On the
yes, all right. Then you can show.
No, Your Lordship, it's
if it is
based
not on charge, it will not be relevant.
Your Lordship, it is regarding the
it is regarding that. So that is a different consideration.
Yes, Your Lordship. The case law is regarding the reliability of reliability on the.
That will not be relevant. If you want to read, you can still read it, but it will not be relevant.
Yes, Your Lordship. Counsel would like to continue with the arguments. In this particular case, the Supreme Court had stated that the testimony of the victim of rape cannot be presumed to be gospel truth, and observed that false allegations of rape can cause equal distress.
So what does it mean if it is not gospel truth? It can't be relied upon at all.
No, that the Supreme Court in this particular case, Your Lordship, has stated that it cannot be.
Truth, therefore there will be discharge. There will be no charge. Is that the law?
No, Your Lordship. It can be. It is the case observes that the testimony which is here used by the prosecution to prove the charge of rape is. It could be harmful for the accused also in case of a false rape charge, and which is why whenever looking at the testimony of the victim in the particular manner, it cannot be considered as gospel truth. Your Lordships, if the counsel could continue with the argument.
You can go ahead. We have given our view.
Yes, Your Lordship. Your Lordship, moreover, another point that the defense would like to put forward is that no documents certifying the age of the prosecutrix has been collected or submitted before the Honorable Court, proving that she was a minor. Even if the victim is considered a minor, the age of victim is mentioned as 15 years in the introduction regarding her statement under under the statement 1 of 164 of, it's mentioned in page 33 of the Moot proposition. It is also mentioned that as 15 years in the medico-legal injury register, which is in page 35 of the Moot proposition. But here it is not backed by medical evidence, but is just written by the medical officers through the information provided by the investigating agency. In the lack of certification proving the age of the victim, it would be unjust to invoke the section of 376 DA in the present matter, Your Lordships. Moving on, though eyewitness testimonies are considered vital for dispensing justice, quite often inaccurate eyewitnesses can lead to wrongful conviction. There are many contradictions within the statement of the eyewitnesses. The complainant in her statement said that the accused persons were trying to do unhuman acts of outraging the modesty of a girl, which is not equal to rape, Your Lordships. Also, they stated that there was immense bleeding from the private parts of the victim. However, this has not been recorded in the medico-legal report. Your Lordships, it is also to be another point to be noted here is that in page 13 of the prosecution's written submission, prosecution have mentioned about confessions of the 4 accused. However, confessions made by the accused persons were in police custody. And according to section 26 of the Indian Evidence Act, no confession made by any person whilst he is in custody of police officer, unless it is made in immediate presence of magistrate, shall be proved as against such a person. Your Lordships, also in page 18 of the written submissions made by the prosecution, they have stated that the accused persons provided new information that is admissible in court. The prosecution has went on to submit that in their written submissions that the accused persons kidnapped the victim from a school van. This has nowhere been mentioned in the factual matrix, Your Lordships. Proceeding to the next limb of issue, section 120B, Your Lordships, it is submitted before the court that there is no criminal conspiracy in the present case. Your Lordships, the essentials of 120B of the Indian Penal Code according to Rajiv Kumar versus State of UP are that first, there should be an agreement between 2 or more persons. And second, the agreement which is formed must be in relation to committing an illegal act or an act done by illegal means. Your Lordships, in the present case, there is no evidence to prove that the that criminal conspiracy has been committed. Conspiracy precedes the commission of an act. Nothing from the state.
Before the act, they have come together.
Your Lordship, this too has not been clearly stated in the factual.
All the 4 have come together.
Your Lordship, could you repeat the?
All the 4 have come together before the act. Before
all,
the...
Yes, Your Lordship.
What 4 have they come together?
Your Lordship, it is to be noticed that all the accused persons live in the same neighborhood.
No, living is different. They have come to the place of occurrence together.
Your Lordship, another point that is to be noted here is that this is a vacant plot. It is just a vacant plot, and another point that has to be brought forward is the contradiction within the statement of the prosecutrix. She said that she was led to a vacant street in her statement to the magistrate, and in her statement to the police, she has said she was taken to a vacant plot. So this does the meeting of all the accused persons in such a vacant plot is not surprising considering how they all belong to the same locality. And it is normal hours during the morning that they were by the area or at the alleged crime scene, Your Lordships.
Why are they carrying weapons?
Your Lordships, again, the argument regarding possession and use of the weapon here will be dealt in the next section of the argument when we are dealing with charges under the Arms Act. Will that suffice, Your Lordship?
No, whatever way you want to proceed. Yes.
Much obliged, Your Lordship. So counsel would like to just state that it is to be noted that all the accused persons live within the neighborhood where the alleged crime occurred. Thus, it would not be surprising for the alleged persons to be present anywhere near or even at the alleged crime scene. The said crime is a
No, but the allegation is not mere presence. They are doing something else.
Your Lordship, we will be again, the council has put forward submissions contending the reliability of the statement of the eyewitnesses too in the present matter, who are the eyewitnesses, plus also the statement of the prosecutrix, which are the only evidences that are used to charge the frame of section 376DA, 363, 120B, as well as section 34.
How many witnesses are required to be there? Is there a minimum number of witnesses prescribed?
No, Your Lordship. Indeed not. There is no such requirement for a minimum number of eyewitnesses in the present matter. If
So if prosecutrix alone says and proves and the court finds it to be reliable, is that not enough?
Yes, Your Lordship. However, what the counsel would like to put forward is the contradiction within her own statement. If her own statement contains multiple contradictions regarding how and where the offense of rape and kidnapping was committed, such testimony cannot be used to charge the accused persons with the said crimes.
But a minor who has suffered such an incident, do you expect her statement to be uniform and accurate in all particulars?
Your Lordship,
when we are dealing with the statement of a prosecutrix, especially a minor prosecutrix in a rape case, are those standards which apply to contradictions in statements, do they apply with equal force?
Your Lordship, it is understood that minor contradictions within statement is fine. There are judgments that state that minor contradictions within the statement of the prosecutrix can be overlooked by the court when it comes to charging or convicting the accused
All
person.
right, let us put it this way. Do you have a single judgment in which, on the basis of contradictions in the statement of a minor prosecutrix in a rape case, the accused has been discharged? Not acquitted, discharged. Is there a single case?
Your Lordship, at the moment, counsel does not have a case to.
All right.
Counsel would proceed with the arguments. Your Lordship, so in the case of state versus Parveen versus state of Haryana, mentioned in page 12 of the memorial, it was said that it is difficult to establish, though it is difficult to establish conspiracy by direct evidence, but if there is an absence of any evidence showing the meeting of minds between the conspirators for the object of committing an illegal act, it will not be fair to hold a person guilty for the crime of conspiracy. Your Lordships, moving on to the next limb of the argument.
Just a minute. Counsel cannot the commission of the act in the place jointly by all of them prove the meeting of mind before that? An inference can be drawn. There is a meeting of mind, and they have assembled that for performing this act.
Your Lordships,
otherwise, why should they be there?
Your Lordship, the counsel would like to prove that the act of the crime of rape has not even occurred in the present manner. The accused persons are being falsely implicated in the present matter, Your Lordships.
That's a different thing. It's only with regard to absence of meeting of mind and the act done by them proving that there was some meeting of mind before them. Otherwise, why should they assemble that together and bring the girl there?
Your Lordship, which is why counsel had brought the contradiction in the statement, which is not a minor contradiction.
The contradiction, there is no contradiction with regard to the fact that the four were present in that place and certain things happened there.
Yes, Your
The
Lordship.
contradictions may be on different issue, but as far as the presence of the four persons at that place where she is brought, there is no contradiction to that effect.
Your Lordship, counsel would like to reiterate the point that all the accused persons live within the locality, which is why it is not unusual for them to be there present in the vacant plot. They could have been.
But it is unusual for one of them to bring the girl to a place where the other three are also present.
Your Lordship, counsel will be dealing with the charge of 363 in the argument ahead.
Proceed.
Already half an hour is over because 45 minutes are allotted. So you decide whether you will like to continue or you have another co-counsel who can continue.
Your Lordship.
You can sum up your argument. We have understood what you are saying.
Yes, Your Lordship. Counsel would quickly conclude the argument.
Yes.
Your Lordship, in the present manner, directly moving on to section 363, the charge of section 363, it is submitted that prosecutrix was not kidnapped by the accused persons at all. In the present case, the prosecutrix is contradictory in her statements made to the police and magistrate. In her statement to the police, the prosecutrix stated that she was kidnapped by all four persons on motorbike. However, in her statement to the magistrate, the prosecutrix stated that she was forcefully taken to the plot by accused person Rakesh Kumar. This is not a minor contradiction, Your Lordships. The prosecutrix herself is unsure as to how she was allegedly kidnapped by the accused persons. The story of kidnapping has been concocted and the accused persons have clearly been falsely implicated. It is also to be noted that there are no eyewitnesses for the kidnapping of the prosecutrix that could corroborate the statement of the prosecutrix in the matter of kidnapping. It is also to be noted a victim was allegedly kidnapped has not been seized by the investigating agency. Counsel will quickly proceed to the issue relating to the charges regarding Arms Act. Your Lordship, the accused persons are not guilty under section 25 and 27 of the Arms Act. It is to be noted that according to the statement of the prosecutrix, the accused Rakesh Kumar shot a bullet at the residents while they were coming to rescue her. However, this noise was not heard by anyone else in the locality, Your Lordship. Another point to be noted is the ambiguity regarding the seizure of the empty cartridge case that was said to have been shot at the residence. There is no mention of the empty cartridge case being obtained at the crime scene, and spent bullets are usually found at the crime scenes found at crime scenes than the gun itself, Your Lordships. Even if it was seized from the gun, there has been no mention about its seizure in the property seizure memo. This is why counsel would like to state submit that the exact usage of the weapon is unproven. Some important technicalities that the court may be pleased to observe are that firstly, the property seizure memo has described the gun to be black in color, while the picture show that it's golden brown. Also, Your Lordships, the ballistic report after examination of the firearm states that the firing pin and breech face marks on the weapon are similar to that of the firing pin and breech face marks of the testing weapon. However, the question is whether similar can be construed as exactly the same. Furthermore, Your Lordships, as per the allegations of the prosecutrix and the witnesses, the accused one, Rakesh Kumar, was holding the gun while raping and also fired a gunshot, which is a considerable time, Your Lordship. And in this time, and later when the gun was seized by the police and examined, there was no presence of the fingerprints of the accused Rakesh Kumar in the present case, which questions the possession of the firearm by Rakesh Kumar and its use, which is a charge against him, Your Lordship. With that, counsel would like to conclude the arguments regarding IPC sections as well as Arms Act. My co-counsel will be dealing with the charges under juvenile justice and the POCSO Act, Your Lordships.
Your Lordships, the issue that counsel will be dealing with is whether the accused is guilty under sections 6 and 8 of the Protection of Children from Sexual Offences Act, POCSO 2012. Your Lordships, counsel humbly submits before the Honourable Court that the 4 accused are not guilty under section 6 and section 8 of POCSO Act. Your Lordships, a major point to be noted is that there is no proof of age of the victim girl been submitted before the Honourable Court by the police officials. It clearly indicates that the police didn't investigate the age of the victim. Prior to that, the police made the report and framed charges against the 4 accused under POCSO Act as well as 376 DA, which deals with gang rape of a minor girl. Your Lordships, in the case of Sri Anwar Hussain Sheikh versus State of Meghalaya and another, the Meghalaya High Court observed that it is incumbent upon the court hearing a POCSO case to be certain of the age of the victim proceeding with the matter. Your Lordship, over here, there is no proof of age given of the victim. The court and the prosecution and defense counsel at this particular point should be blind to the age of the victim, as there is no proof given whatsoever. Your Lordships, there is always a reasonable suspicion that the schoolgirl's age may be above 18 years. This is not an impossible incident. There is a possibility of the same happening in the present case. Without investigating such a grievous issue, which is essential to the charges under POCSO Act and even under 376 DA of the IPC, the police arrested the accused persons under these 2 acts. It is a gross violation of justice, Your Lordships, and indicates an extremely incompetent investigation from the very beginning. Furthermore, Your Lordships, keeping this huge issue aside for the time being, counsel would like to bring up the fact of the sole testimony of the prosecutrix being used. Your Lordships, as stated by the Learned Defense Counsel in the state of Himachal Pradesh versus Raghuveer Singh, it was stated that if it inspires confidence and is consistent, if it is compelling, Your Lordships, in the present case, the testimony of the prosecutrix is not at all consistent. In different aspects, there are different facts mentioned, and as of what my co-counsel stated, it is not minor discrepancies, Your Lordships. Furthermore, Your Lordships, another major point that the prosecution counsel would like to bring forth is the fact that the medical legal report was done by DDU Hospital, MLC number 6222, dated 2nd February 2022. But the MLC report submitted before the court is that of Sanjay Gandhi Hospital, Delhi, MLC number 153. Your Lordships, if the report done of the prosecutrix as per the FIR, that is the initial report, is that of DDO Hospital, why has the report of DDO Hospital not been submitted? That brings up extreme suspicion, Your Lordship. Furthermore, the Learned Defense Counsel used the term compromising position that the eyewitnesses saw the 4 accused and the victim in. Your Lordship, in the present case, prosecution counsel would just like to state that there is no compromising position. A compromising position would arise if the prosecutrix was bleeding, as per what the defense counsel stated, but that hasn't been recorded in the medical legal report, Your Lordships. Furthermore, these statements of the eyewitnesses are under 161 after all, and
so
are
is
not.
That your madam? Is that your understanding of compromising position? That if the victim is bleeding?
Your apologies, Your Lordship. The only what the prosecution counsel meant to state is the word compromising situation hasn't been used by any of the witnesses per se. What they've stated is that when they came to the plot, they saw the girl bleeding and the 4 accused running away. However, at this point of time, the fact that the girl was bleeding is not corroborated by the medical legal report which was submitted, Your Lordship. That is the only contention that the prosecution counsel wishes to put before the honorable bench. Moving on, Your Lordships, it is the prosecution counsel would like to state that although injury, as the learned bench stated, is not mandatory, it is not stated that only if there is injury, there has been rape. However, all the prosecution counsel wishes to state is that according to the factual matrix, that is, according to the statement of the prosecutrix, according to the supposed eyewitnesses, there has to have been some sort of injury. That is what can be inferred from the factual matrix. However, there is no external or internal injury when it is indicated that there was supposed to be some sort of external or internal injury, your lordships.
You wanted to say 161 statement.
Pardon,
You wanted
your
to
lordship.
argue on 161 statement being not admissible.
Your lordships, you want me to argue on the 161 statement?
You wanted to argue. You wanted to say, we don't want you to argue, but you wanted to argue.
Your lordships,
You are trying to recollect what you are arguing. They are
Much
only trying
obliged,
to
your
help you to remind you that you had started arguing, but you got on to other point that 161 statement is not admissible.
indeed, your lordship. Your lordship, the 161 statements is not admissible in court unless proved in trial, and the same has been stated in section 162 of the CRPC.
But it is not being relied upon to prove the charge. It is only for charge.
Indeed, your
161
lordship.
statement is there for the benefit of the accused so that he can cross-examine. He knows what is the version of the witness.
Indeed, your
And
lordship.
it can be used for contradiction.
Indeed, your lordship. Understood that.
But
Your
in the
lordship,
at charge stage, there is no other evidence except this material.
Indeed, your
It
lordship.
can be considered for charge.
Indeed. Your lordship, on this particular issue, counsel would like to just sum up the arguments. Number one, the age proof hasn't been given. Number two, the apparent medical legal report submitted before the court is not the medical legal report that was conducted. Thirdly, the statement of the prosecutrix, as stated by the learned defense counsel, to be brought into, to be considered, is not, it does not inspire confidence, and it is not consistent, as there are many discrepancies, as me and my co-counsel have stated. Your lordships, moving on to the next issue, whether the accused Rakesh Kumar is to be tried as an adult. Once again, prosecution counsel would like to submit before the honorable court that age documents of Mr. Rakesh Kumar has not been submitted. It is not yet known if he was above the age of 16, if he was 16, or if he was below the age of 16. Your lordship, in the present case, according to the laws and according to the provisions of the Juvenile Justice Act, if he was below the age of 16, then he cannot be tried as an adult. Your lordship, the fact that the age documents are not submitted is of immense importance. Furthermore, your lordship, there is a procedural inconsistency here that the prosecution counsel would just like to bring before the court. The police have arrested the minor boy without witnesses in the present case, which is in contravention to the provision of section 41B of the CRPC. Moving on, your lordships, in the present case, when the prosecution has not particularly proved or brought in substantial doubt that there has been rape or there has been kidnapping. Your lordship, in the present case where the age proof isn't there of the accused, and even when these two offenses which can be committed as heinous offenses, as it has a punishment period of 7 years or more, if these hasn't been proved, then Mr. Rakesh Kumar cannot be tried as an adult. Furthermore, your lordship, an important question to be asked here is if sexual assault or if rape or kidnapping even did occur here, because in the present case, if it was perhaps in a hypothetical situation, if it is only physical assault or outraging the modesty of a woman that happened in the present case, then those offenses don't have a minimum period of 7 years of punishment. Thus, Mr. Rakesh Kumar cannot be tried as an adult in such a case. Furthermore, your lordship, the learned defense counsel stated that in the factual matrix, the assessment by the Juvenile Justice Board stated that he should be tried jointly with the other adults. Your lordships, this is false. In fact, according to the charge sheet, section 23 of the procedure must be followed, and section 23 of the procedure clearly states that the child is not supposed to be tried with any other adult. Council would like to state one last point before the learned bench, before moving on to the prayer. In the present case, your lordships, the number and gravity of inconsistencies and discrepancies are too high and are of too much gravity for it to just be sidelined by the learned bench. Almost every document submitted before the Honorable Court is overridden with inconsistencies. Furthermore, multiple documents have not been submitted before the Honorable Court, which should be submitted for these particular charges to be brought in. Prosecution Counsel humbly pleads before the Honorable Court to consider all such major matters while making their decision. Moving on to the prayer, your lordships. Wherefore, in the light of the issues raised, arguments advanced, and authorities cited, the counsel for the defense humbly prays that the Honorable Additional Sessions Judges Court be pleased to discharge the accused of all charges put forward by the prosecution. It was a pleasure arguing before this Honorable Court.
Thank you. Thank you. Thank you so much. Is that over?
Your lordships, I seek permission for 2 minutes of rebuttal.
Is it necessary? On what point you want to rebut?
Your lordships, I want to rebut on two primary points. Your lordship, my learned friend mentioned here that the Rakesh Kumar cannot be jointly tried as an adult due to the fact that he is below the age of 18 years. Your lordships, but the Juvenile Justice Child Welfare Board has conducted an assessment, and on the basis of this assessment, they have held that he can be tried as an adult. Your lordships, the prosecution has provided no opposition to the claim or to the decision of the board, and unless they have any material on record, they cannot claim that this decision is unjustified. Your lordships, my learned friend also mentioned the non-recovery of the bullet. Your lordships, I would like to cite the case of state of Rajasthan versus Arjun Singh here, where it was held that if the circumstances and the actions of the accused justify that a weapon was used, then there is no necessity that a bullet must be recovered from the crime scene in particular. These are my primary 2 points of rebuttal.
Thank you. Thank you.
Your lordship, if I could just address one of those points. Your lordship, the only statement that the defense counsel would like to say is that there is no age proof given of Mr. Rakesh Kumar. In that case, how can it be stated that he should be tried as an adult? Or if, yeah,
thank you so much. Thank you so much to all of you.
I would thank the judges for their time, and I would also like to request the judges to please prepare the mark sheets, as we are going to announce the results in this live session.
No, we will do it right now. I think the teams can be discharged. Then we will discuss and give the marks right now in 1 minute.
My lords, we can prepare a separate link for you, because there are other speakers in this live link who are going to address the students.
No, can you join the judges separately?
Yes, my lords, I'll give a separate link
for 5 minutes. And take a break so that we can complete our work.
My lords, the difficulty is this session is going
live.
live.
We will connect ourselves on our phones.
My lords, that will be very great if my lords. Otherwise, I can prepare a separate link of Google, and I'll share it.
We will connect on phone.
Yeah, we will connect
on our phone.
That grateful, my lords. Grateful.
We will connect on conference, and we will come back. Yes. Till then, we will put off our video and speaker.
Yes.
Yes.
Grateful, my lords. Grateful. We are waiting for my lords to.
In the meantime, the results have been prepared. We have with us Director of TC 155 and faculty coordinators of Moot Court Society of Team 107. I request the Director of TC 155 to kindly come for a motivational lecture for the students. Am I audible, sir? Yes, sir. We have Dr. C.J. Ravandle, Director of TC 155, to kindly come for a motivational lecture. Namaskar, sir.
Namaskar, namaskar. Am I audible and visible too, ma'am?
Very well, sir. Very well.
Okay. Namaskar. And in the common language, so understood today, it's good evening. It's an honor, of course, to address to young learners who are participating in the prestigious Moot Court competition. Well, I'm not here to motivate because I'm still looking for my motivation in life, which has come long way through teachers whom I fondly call as Gurujis, who have that impact on my life. I just have one message which was given to me by my grandmother and which I've shared with my students quite often. That what matters a lot in this world, it's a small story, ladies and gentlemen. After being ranked third in a debate competition, which was my first ever competition participation at Standard 5th, I went home, not in a joyful mood, but in what we call as crybaby mood. And my grandmother just asked me this question, why are you crying? I just said, they gave me third rank. So in my language means today when we say about law terms, we say it is not justified. So she said, it's all right. Let us play a game. So she said, close your eyes. I just closed my eyes and my grandmother asked, what do you see? I already was ranked third and my grandmother asked me this question. What do you see when you close your eyes? I was so perturbed and I said, because we call grandmother as Madi. So I said, Madi, how can I see when my eyes are closed? She said, oh, yes, good. Now can you open your eyes? I opened it and then I asked, she asked, what do you see? Then I said, Madi, I see you. And of course, I'm an animal lover. So my friend who then, of course, a dog, his name was Lalu. I said, I see you, I see Lalu. She said, oh, fantastic. Now close your eyes. What do you see? By then I was a bit relaxed and I said, I don't see anything when my eyes are closed. So she said, what did you get from this? She gave me the important lesson of life, that the world exists when you exist. So if you see, the world exists. If you don't see, the world doesn't exist. So whether you win or lose, whether you receive the first, second, or third rank, that doesn't matter. What matters is you. So please keep doing the work, ladies and gentlemen. Never get perturbed by the thoughts that I presented so well, but I did not get this or I did not get that. But we forget the larger picture. That larger picture is that you invested so much of time in learning, further unlearning, then developing your talks, your discussions, your arguments, and you presented it before the best from the legal field in the form of 3 honorable justices. So please take this value system that yes, you did, you learned, but at the same time you unlearned more. And I also would like to draw your attention to the efforts of the organizers. Generally, we tend to forget the one who makes it available for us, which comes to us as an opportunity. We tend to forget them and thank them. So they owe a big thank you because they gave an opportunity where I could connect with you. You all could connect with each other. You could get an opportunity to address each other, interact with each other, counter each other, but at the same time, look at your faces, at least the few faces which I'm seeing, they're quite happy. And I was just listening to your argument. Take my word, ladies and gentlemen. When I was in my law school, I did not know a bit of it. And that's a fact. And over the period, what we all have been learning is this thought. So I will not take or say much on this because I'm still a learner. And we have this term which we constantly use at the law school, because we don't say anybody as a student or a teacher, or we say as a non-teaching staff. We have a term called as learner, because somebody said learning is a constant process. I don't say that. I say learning is a process and we are constant part of that process. So let us give importance to yourself being the constant, and don't forget to respect the process wherein the learning happens. So thank you very much, ladies and gentlemen. And thank you very much to everyone, and especially the Adhivakta Parishad that you every year have been organizing. And students are participating and they're taking a good value system. Please keep up the good work, and ever you require any assistance from our end, we are just call away. And I'll just give one message that once I will be sending an invitation to you that we have, means please don't take it as something the law school is saying, but as part of the society, that the library is open to everyone. They can come, they can sit, they can read, use the resources, because learning shall have no boundaries, no restrictions, no obstacles. But a learner is always welcome to the institution where I'm learning. Thank you very much, ladies and gentlemen. Namaskar.
Thank you so much, sir. Your words were very motivating, not for only TC 155, but for 107 and for us as well. And sir, definitely, it was so kind of you and so humble of you that you were available to us. Thank you so much. We also have with us the faculty coordinators of Moot Court Society of TC 107, Mr. Ashwin, Mr. Karan, and Ms. Pavitra. I request Mr. Ashwin to please come for the feedback.
Yes, ma'am. Thank you very much. I hope I'm audible. All right. Very good afternoon and good evening to everyone present here. As ma'am stated, my name is Ashwin Kunal Singh. I'm here with my co-coordinators of Moot Court Society, Mr. Karan Singh Chauhan and Ms. Pavitra R. And first and foremost, I need to say that it's such a great honor to share the stage with such eminent personalities in the legal field. And even I think the students should realize as to, what dignitaries actually they've argued in front of. And if you're not aware, just after this session, go back and just Google and just look at their extensive CVs. It's quite amazing. Anyway, that being said, I think little credit also needs to go to ABAP for organizing this Moot Court competition. I think it's a great initiative. And speaking from personal experience, it's not easy at all to organize these Moot Court competitions. And from personal experience, we know what many things can go wrong. And I think they've done a fabulous job at that. And that's really amazing. This is their third one. And I think many more to go in the future as well. Coming to the most important stakeholders for Moot Court competitions, I would definitely say are the students, of course. And, at this stage, obviously in the finals, you obviously tend to think that, I hope I win. I, hope I did well. I hope I get best speaker and things like that. But let me tell you, at least I can recognize my students here, and not to give away too much, but they're not very senior students. And at this stage, trust me, it really doesn't matter. At this stage, it might feel to you that, if we work so hard and we don't win, then it's quite demotivating, but it's exactly the opposite. It's not about winning or losing, especially being in a university, it's about learning. I think you guys did fabulously, especially in the face of adversity. The judges were questioning you guys. I'm talking to both teams here. And the way both of you, kept your cool, responded, managed time, I think that was really good. I mean, I was fairly impressed. I kept my video off, but I was actually listening for most of it. So it was quite impressive as to how that went on. And I think that's fabulous. I don't know much about the other team. They also look like a junior team based on at least their faces, but you can't tell nowadays, I guess. But yeah, and also with what Sir said before me. And I think that should be a main takeaway from today is that, at no stage do we stop learning, right? Whether you're a professor for 5 years, whether you're a student for 1 day, it makes no difference. Law is an ever evolving subject, right? At no point can you say that you know everything or you've studied everything. It's forever evolving, and we're all students of law, no matter what stage where we are in our career. And that's it. May the best team win. I'd hand it over back to the organizer now. Thank you, everyone.
Thank you so much, Ashwinji. And thank you for the acknowledgement that yes, it is a very big task and being professional lawyers. So it's a double task for us. Thank you so much. So first of all, I request all the members to please switch on their cameras. In the meanwhile, we also have with us Shri Srinivas Murthy ji, Senior Advocate. Sir is also the National President of Akhil Bharatiya Adhivakta Parishad. I request you, sir, for the concluding remarks. Sir, you are muted. Please unmute yourself. So please conclude with your motivational remarks.
Right.
Yes, sir, you're audible now.
Now I'm audible. Good evening, everybody. Namaskar. I apologize for joining this a bit late because I was rushing from the court. Today is a holiday for Delhi and other people, but here in Hyderabad and Vijayawada, it's not a holiday. So I had to be in the court till 4:15. And in the meanwhile, I just now and then switching on the link and looking at it. I am really happy to see so many participants with such a motivation participating. Actually, I'm jealous of you. Because when I was doing law with 85, 88 Usmania Law Campus, we never had such an occasion. I always wanted we wanted to have the moot courts, but in those days, they were not encouraged or they were not being done. No one could do this. And I'm happy that Adhivakta Parishad Delhi unit, High Court unit has taken up this, and several moot court competitions are going on, which I missed it. And regarding what I should speak, I did my MSc Physics from University of Delhi, from the Center for Advanced Research Physics at the North Campus. Then I represented the University of Delhi in inter-university debating competitions, which took place at Kashmir, 1984, I'm talking about, okay? 84, September, October. After that, I came back to my native place at Hyderabad while doing law. So my lecturer asked me, I was in the final year. So you're a inter-university debating competition participant, and one or two places also you won. So I think you'll make a good lawyer. That's what a lecturer said. Then I really felt, would I make a good lawyer? Then when I went to join one office of Parvatrao, later he became a judge, and he was also the president of Adhivakta Parishad. So I told him proudly, sir, I am a good debater. He said, boy, debating is different. It's a different ballgame. Debating gives you confidence to speak, but arguing with a court of law is a different ballgame. He said that, and he said, you're a good debater, go and ask for an adjournment. I went in and asked for an adjournment. The second day of my practice, the judge misjudged his mind and said, whom are you representing? Sir, I'm representing Parvatrao. Okay, are you representing petitioner or the respondent? So blah, blah, blah. Okay, then why are you asking adjournment? No, he couldn't say anything. Then my senior colleague was there. Later, she became a judge, just retired just 1 week back. She was sitting next to me. She laughed off and she said, the adjournment, I'm appearing for respondent. We want to file counter, blah. So while going into a courtroom, you should know what you're asking for. You should know what you want. And even for an adjournment, that day she told me, even for adjournment, you should know what are the dates, what are the earlier proceedings, etc. by speaking. So even asking for adjournment in a court of law is not an easy task. And in one of the, I won't name the court, I went to visit one high court. There one senior counsel was saying, I will get you adjournment, I'll charge you so much. Heard it? So it was very difficult. I went in and saw him. The way he crabbed and got the adjournment because the clients wanted adjournment so that they wanted to go for some settlement. So why I'm just saying this is that the debate, the competitive spirit in a debating competition is quite different in a court of law. And all of you have been exposed it, and as I said, I heard, meanwhile, middle, some of the participants. I'm happy to see that all of you were confident, were speaking with a clear-cut mind and approach. And yes, sir, then what is the difference between a debating competition and a argument in a court of law? Remember, court of law, argument, please don't look at a case just like 1 + 1 is equal to 2, or 2 + 3 is equal to 5, or 2 × 2 is equal to 4. Right? There is something else to mix. There is something else, the magic portion you'll be learning from your own experience. Right? No one will be able to tell you. You might be seeing someone doing it, but you will know how to mix this magic portion. The correct approach to law, appealing to the judge. Remember, the judges are human beings. Artificial intelligence judges have not yet come. I think in Europe, in some countries, they're trying to plan it, but not here. And how you are appealing to a judge, and before you go into argument in a court of law, please remember, I think most of you are going to get into profession. That's what it looks like that. Okay. Please remember that just listen at least half an hour before your argument. What are the judge saying? What are the types of questions you would ask? What is it he's asking? Where did you state in affidavit? Where is the document number so-and-so? Is it clearly typed? He'll be asking those questions. Each judge has got his own mind to approach the case, and he'll be asking his own unique questions. And if you know what they are, you are halfway done, 50% through. And you will know more and more. But in the beginning stages, you file a case, you prepare a case. While preparing case, after preparing your case or before preparing case, for 5 minutes, just think what if you are in the other place, right? You are appearing for a defendant. If you are a plaintiff, what would be your stand? Think like a plaintiff, then preempt those questions, that strategy in your opening remarks. You understood? While drafting a plaint, you should think like a defendant and think what he is going to say about you and plan it. You know it. And this is a noble profession. Elders must have told you about the noble profession, the importance it costs towards society, how the entry of advocates changed the texture of freedom movement or independent India after 74, what happened, etc. The advocates have got role to play. Not only a noble profession, it's quite a crazy profession also. I think you must have heard about it. I'll just say you must have heard about it. One young advocate like you and me, we walk into a court hall. So after 1 week, our friends ask us, so who knows the law? I would say, my senior is the best person who knows the law. Then after 10 days, again we met. Who knows the law? I think my senior doesn't know much of the law. Other side advocate knows better law than my senior. Then after 1 month, this man would say, what's happening, man? Boss, both advocates don't know the law. Only judge knows the law. After 2 months, we go for a party. Then this man would say, boss, neither the judge nor the 2 senior advocates know the law. Only I know the law. Okay. That is the confidence we get each time, because the elders, the senior advocates like me might have missed the latest case law. Now you got a tab. You'll be saying, sir, today morning, Supreme Court judge said this. This is the case law, latest case law. You'll be updating yourself, be fighting for it, and you'll be dealing with humans. I know many of you will be going to corporate law also. Even while going to corporate law, please remember that you'll be dealing with humans, society. And society in all the countries, society will be, it's a regular dynamic. It will be searching for various questions, answers, solutions, what you want to do, etc. Okay. Then that process, without knowing yourself, you'll be modulating the society's response to the various issues. You'll be articulating their problems. The client comes to you, talks to you for 45 minutes, 1 hour, only 2 points will be relevant for you. Okay. Then only you will be knowing how to write this stuff, how to articulate their issue. That is most important. Please remember that you are not just dealing with one like a Supreme Court scholar of the American Supreme Court said, don't be a paying machine, right? Or don't be expecting a regular paying machine. You are not a machine. You are dealing with humans. Just and think with your heart along with your mind also. Then you will have the appropriate satisfaction. And remember, ultimately, it's like this. Between the David and Goliath, when you appear for a David and win the battle for him against a Goliath, you will have the appropriate satisfaction. And when you go to a court of law, go to the court of law along with the paper bundle and the relevant statute book, the book. Okay. And along with that, you should have the latest 1 or 2 case laws. I know many judges who would say, where is the statute? What does the section say? What does that say? Remember that. And I'm sure next time when we meet others, when we go to other places, I should be hearing that the young advocates, remember, you think unconventionally, right? I know we'll be talking of presidents, 1964, Gajanagatka, 1965, Desai, 1971, Krishnaya, 1977, so-and-so, 1980, Dhananjay Chandrachud's father, that Chandrachud, Junior Chandrachud, Faniman. Conventions are there, but younger generation must bring in, and we all look forward for you to bring in new ideas, new interpretations, and break the regular mold and glass ceiling. Okay? Hello? Hello? Yeah. Now, just keep that in mind. And as I said, next time when we meet for a conference or something, hope to listen success stories from you and learn to be professional. Don't believe anyone who gives you any shortcut. All the best. Thank you for the Delhi High Court unit for bearing with me and sparing me 5 minutes. Thank you all.
Thank you so much, sir. So the results are with us now. So I know participants are very much curious to know the results. But before that, first of all, we would like to have the motivational remarks and the feedback from the honorable judges, the bench for the day. First of all, I would like to request Shri Adarsh Kumar Goyal ji. I think there is some technical glitch. Sir has left. We have with us Honorable Mr.
Ridhima, I'm there. Ridhima.
Yes, sir. Yes, sir.
Justice Goyal has to go somewhere, so he has asked us to excuse him for the day, and he has asked me to take over the baton. Can I proceed?
Ji, sir, okay, sir. So we have, yes, sir, we have with us Mr. Justice Rajiv Menon ji. I request sir to please give some motivational remarks to the students.
Good evening, everybody. The learned guest who spoke before, good evening to all of you. It was a pleasure being in this competition. The participants were really good. It's a certificate to them that they have worked hard on a case which was not in fact a case, but a case pertaining to framing of charge. And they withstood all the grilling from the three of us, particularly Justice Goyal's grilling. They maintained the cool and they behaved in a manner that they were seasoned lawyers practicing in the court regularly. Hats off to you, and I'm really happy to be part of this competition. I thank the organizers, particularly Shri Ashok Kashyap, the president, and Ridhima for having invited me, given me all the assistance in being part of this. Now, as far as the participants are concerned, a few tips or few advice to you. Grilling by us today was a deliberate act on our part just to assess as to whether it will derail you, irritate you, or it will make you come out with your best. It did not derail you. All of you maintained your cool, and all of you came out with the best. But you are all beginners, you are learning, you are students of law, you have a long way to go. And as a judge, as a lawyer, when you enter into the field of litigation and start practicing, the first and the foremost advice which I would like to give you is read the judge, read his mind, prepare your case, and formulate your argument reading his mind. Don't try to be in conflict with him from the very beginning. Try to mold your argument, your submissions, the way the judge would accept it in a better way. And ultimately, if you find that one of your point is not finding favor with the judge, don't lose your cool. Go to the other point, emphasize on the other point. For example, today, when the speaker number 2 for the first team was speaking, and when the interpretation of section 27 of the Evidence Act was going on, the speaker was insisting upon her view on section 27, and to some extent that was not in conformity with the law laid down by the Supreme Court with regard to the confession being only admissible to the extent of discovery. And what is discovery? Discovery of certain facts which lead to certain material discovery. It is not something connected with the act of commission or omission of the offense. So when such things are asked, you should learn to give up. I can give you an example. Once, as a junior lawyer, I was sitting in a court when a senior counsel, when Mr. K. M. Munshi was arguing way back in 1980. He filed a civil revision under section 150, and the judge told him, Mr. Munshi, you are such a senior counsel, you are a seasoned civil lawyer, and do you think there is any substance in this revision under section 150? He did not waste even a minute of the judge and said, my lord, I know it. I told my client that you don't have a case, but he wanted the opinion of the court. I have affixed the court fee of 150 rupees. Please give your opinion. I'll forward it to my litigant. That is how the judge and lawyers used to behave at that point of time. And today, if I tell you that, you will say, no, sir, we cannot do it because today is the period of competition. You cannot afford to lose a single client. And therefore, there is another example of another senior advocate. Once, while again practicing in Jabalpur as a junior lawyer, we were celebrating the 26th of November Law Day, when one of the judges says that when a litigant comes to the court, the lawyer knows the case, the merit of the case, and whether the case will withstand the scrutiny of the court. And even knowing that the case will not withstand the scrutiny of the court, the lawyer files the case and wastes the time of the court. This was what the judge said. And in retaliation, in rebuttal or in reply to that, Mr. Y.S. Dharmadhikari, the then Advocate General of Madhya Pradesh and senior advocate, replied and said, sir, in reply to what you said, I want to give you an example. And he said that a client came to me. It was a service matter. He wanted to challenge a charge sheet. I told him that High Court under Article 226 will not interfere with a charge sheet at this stage. It is better to face the inquiry and then come after you are punished. He went, the Justice Dharmadhikari said, I asked the client to go away. He went away. And after 10 days, while I was walking through the corridors of the High Court, I saw the same client coming towards me, laughing and telling me, "Saab, aapne to kaha case file kari hai, mujhe to stay mil gaya." And that Justice Dharmadhikari said, "Sir, why should I lose my client? The litigant comes to me, it is my duty to file the case, and it is for the judges to take a decision." So dear friends, there are various aspects of the matter, but you have to take a decision, because ultimately you are standing in the profession. Your reputation, everything depends on the way you present yourself in the court. Be honest, be submissive to the court, understand the principles of law, be prepared on fact, do your best, assist the court as an officer of the court, and don't be result oriented. These are few of my advice to you at the fag end of my career, where I have been for more than 42 years. Many of you in the younger generation who are facing this competition may not agree with you, but my advice is, this is the way you should practice. And today, all of you showed that the generation which is being built up will change the system, the law, the litigation is being practiced in this country. I'm very hopeful, and I wish that all of you prove that you are the best in the field. Thank you very much, and God bless all of you. Jai Hind, Jai Bharat.
Thank you so much, sir, for your enlightening remarks. I can actually see the curiosity on the faces of the participants, but let's take this more ahead. We have with us Honorable Mr. Justice C. Harishankar. Sir, I would like you to kindly come for the motivational and concluding remarks. Sir, you are muted. Please unmute yourself.
Yes, the first thing I must say is, there is a world of difference between mooting and arguing in a court. Right? A moot court is literally trial by fire. It is, as counsel, we are eternally grateful that we don't have to face in a regular court what participants in moot courts face. I mean, if we were to be told that in 15 minutes or 20 minutes you finish your arguments and be subjected to questioning in between and all that, and to give a memorial, etc., it would become very difficult to handle a matter. But in courts, we have the luxury, we can argue as long as we want. No one is going to tell us to keep quiet, except some judges will say, all right, enough is enough. But so therefore, you must treat a moot court literally as trial by fire. If you can do a moot court properly, I think you can manage a regular court with ease. So given that, I must say that I reiterate what Justice Menon said, that the standard of discourse in this moot today was uniformly high. And given the circumstances in which you were placed and the number of questions which were put to you, I think no one can at all fault with the performance of the candidates. And at least so far as the grade markings which I gave were concerned, it's just a hair's breadth here and there. I mean, it could have been, if we say one is better, it could be the other. I mean, it's just chance, whatever it is. Actually, all four of you were at par. So far as I am concerned, you were all at par. It's just because there are some criteria and some marks to be given. It's just mathematics that one person gets more and another person gets less. Even I must tell you that the difference is hardly 1 or 2 marks here and there. That's one part of it. Then the second part of it, there are just some tips that I can give. And this is something I tell every law student who joins the litigation profession as a litigant, as a litigating counsel. Always answer the question that the court puts to you. This is the most important thing that you must know as a counsel. I learned it from my father, and that is something that I maintained through my practice. never dodge a question. Especially if the answer is against you, it is all the more important that you should answer it. Because a judge who finds that a counsel is straightforward and answers a question, though the answer is against him, immediately has a tilt in favor of that counsel. Because you get the impression that this counsel is honest, this counsel doesn't dodge the question. So if you find there is a question to which the answer is uncomfortable or the answer is against your case, you must say it, and then you try and distinguish it. You try and show how that argument does not defeat your case. That is how you should argue the matter. Not that when you find a question that is uncomfortable, we find very often counsel try to dodge it. Now, judges who are sitting there are people who have had 30 years at least as practice as advocates. We know when a question is being dodged. So that gives a very unfavorable impression. So that's one thing you must always bear in mind. The second thing is never be impatient or irritable in court. Never. Howsoever much a judge may provoke you, howsoever much an opposite counsel may provoke you, never be irritable in court. And always remember to be very courteous to your opposite counsel. That's very important. Everyone is courteous to the judge because you need an order from the judge and you can't afford to. But we find that there are counsel who tend to pounce on the opposite counsel, who tend to bully the opposite counsel. Never ever do that. The courtesy to an opposite counsel is something which is which weighs very heavily in the mind of a court. At least it weighs very heavily in my mind. When I find a counsel before me who is courteous, who is polite to the opposite counsel, who sometimes even compliments the opposite counsel, it gives a very good impression to the court. The third thing you must realize is that this is another very important thing. 10 years of reputation can be damaged in one instance. So be very careful about your answers to the court. If you are not sure of an answer to a query, don't answer it. Read the record. See to it that what you say is not contrary to the record. Because if it is contrary to the record, you may go on telling the court it was a mistake, but the court may not accept it. The court may get an impression that you are trying to mislead the court. So be very careful with what you say to the court. Even one instance, if a court feels you are an unfair counsel, 10 years of reputation you may have made will vanish. And then what remains in the mind of the court is this person is not a fair counsel. So these are all basic things which you will learn as time goes by, but be humble, be fair, be polite, be very well prepared with the facts and the law. You must be prepared with the facts. The law can take care of itself, but you must be prepared with the facts and be polite and be forthright to the court. Don't overstate your case, don't understate your case. And also, just to take on one point which Justice Menon said, sometimes clients will come and ask you to argue impossible cases. Now you have to test the waters there. You shouldn't give an impression to a court that this advocate will come and file anything. Just because then what the court feels is you want to make money. So if the client comes and tells you sun rises in the east, west, you'll come and say sun rises in the west. So you must know to what extent the case is arguable. Definitely, if it is a case which is 2080, you go ahead and argue it. But if it is a case which is 199, don't go and file it just to make money. So because that again gives a wrong impression. So you must be, advocacy is a sort of tightrope walking. It has to be done with precision because today the competition is 100 times what it was when we were there. So you have to be very careful about how you proceed in the court, but be confident, be honest, and always remember you are an officer of the court. You have to aid in dispensation of justice. So with that, as I said, it was a wonderful performance. And I personally am very grateful that you called me. And now I will request my presiding judge or however it is, to announce the results. Justice Menon.
Thank you so much, sir. Your tips are of real importance to everyone outside the court and inside the court. And the students are lucky enough to have you and to learn from you. on this platform. Thank you so much, sir. So to announce the results, because students are too much curious, I can see the curiosity on their faces. To announce the results, we have with us Sri Hari Bonika ji. Sir is the Organizational Secretary of Akhil Bharatiya Adhivakta Parishad, North Zone. Sir joined ABVP, that is Akhil Bharatiya Vidyarthi Parishad, in his teens and was the National General Secretary of Akhil Bharatiya Vidyarthi Parishad. Sir worked in Jammu and Kashmir, Uttar Pradesh, and Northeast for over a decade. In Akhil Bharatiya Adhivakta Parishad, Sir was in charge of university campuses too. I welcome you, sir, and I request you to kindly announce the results. Sir, you are muted. Please unmute yourself. Thank you, sir.
नमस्कार। आज के इस मूट कोर्ट कंपटीशन में मुझे रिजल्ट अनाउंस करते समय बड़ा हर्ष महसूस हो रहा है और अभी सारे मान्य जजेस को सुनने के बाद और 2 दिन कंपटीशन में मैंने कुछ पार्ट सुना है, जिस तैयारी के साथ सारे हमारे छात्र भाई बहन कोर्ट में पेश हो रहे थे और जिस तरीके से वेल स्टडीड विथ कॉन्फिडेंस विथ फैक्ट्स, जिस प्रकार से उन्होंने अपने स्किल का एक उपयोग करते हुए अपने आर्गुमेंट देना और साबित करने का प्रयास किया, तो मुझे लगता है कि लाइफ लॉन्ग सभी स्टूडेंट्स इस मूट कोर्ट कंपटीशन को नहीं भूलेंगे। जब कभी भी प्रैक्टिकली वो कोर्ट में खड़े होंगे तब इन सारी चीजों को वो बार बार याद करें और इन सारे कॉन्फिडेंस जो बिल्डअप है उसका उपयोग करते हुए अपने केसेस को जीतने का प्रयास करें। ये रिजल्ट अनाउंस करने से मुझे बड़ा हर्ष हो रहा है और मुझे जो काम दिया है मैं करता हूँ। बेस्ट मेमोरियल अवार्ड गोज टू यूनिवर्सिटी फैकल्टी ऑफ लॉ सेंटर 2। बेस्ट स्पीकर अवार्ड फ्रॉम खालसा कॉलेज लॉ अमृतसर। Now the second best speaker is Bangla Shroot from Symbiosis Law School, Hyderabad. Congratulations. Fourth award winner, team code number 17, School of Law, Bangalore. And last winner team code is 155, Law School. So I congratulate the runner-up and all award winners for their best future. Keep it up. Congratulations once again. Thank you.
Congratulations, TC 155, Symbiosis Law School, Noida. And the director sir is also here. We congratulate you, sir. Now, for the voter thanks, I would like to request Mr. Ashok Kashyap, sir, President Adhivakta Parishad, Delhi High Court Unit.
सबको नमस्कार। सबसे पहले तो मैं धन्यवाद करना चाहता हूँ सब लोगों का जिन्होंने ये काम किया और congratulations to the winning team and the winners. Before proceeding to my thankful greetings, I would like to mention that today is very auspicious day of Shri Guru Nanak Singh Ji birthday. Is celebrated in all over India, Guru Parv, in the entire country, and I give my best wishes and highest congratulations to all. I would like to thank Honorable Mr. Justice Adarsh Goyal Ji, Honorable Member of the Adhivakta Parishad, Chairperson, NGT of Delhi, NGT of India, former Judge of Supreme Court of India. Honorable Mr. Justice Ajendra Menon gave very, very motivational speech to the students as well as to us. And Chairperson, Armed Forces Tribunal Principal Bench, Delhi, former Justice, former Chief Justice of various High Courts, and also Honorable Mr. Justice Hari Shankar, Judge of Delhi High Court. Hari Shankar ji has given very, very, very good speech to how to behave in the court. That is very important nowadays, to how to behave in a court and how to behave against the arguing counsel, against your opposite counsel. That will be very important in your life. Thank you very much, sir. Shri Konda Srinivas Murthy ji, Senior Advocate, President of Akhil Bharatiya Adhivakta Parishad, who is our guide and mentor. I thank him for his concluding remarks and motivational words to the students. Shri Borikar ji, Organizing Secretary, North Zone Adhivakta Parishad, who announced the result. I thank you for declaration of the result. Thank you very much, sir. We are grateful for devoting your precious time to the final round judges and to all who have contributed their precious hours in semi-final rounds. Judges, pre-quarter judges, final quarter-final judges, preliminary round judges of third National Moot Court competition as judges, organized by Adhivakta Parishad, High Court of Delhi. I also thank Dr. C.J. Ravandle, Director Symbiosis Law of Noida, who has succeeded in the Moot Court competition. I congratulate again to the team, Professor Aswini ji, Karan ji, and Pavitra ji, coordinator of Moot Court Society of Christ University, Bangalore. I, on behalf of and my own behalf of a team of Karyakarta of Adhivakta Parishad and office bearer of Delhi High Court unit, who have relentlessly devoted for time to make success Moot Court competition. I also thank our senior advocate Sanjay Podarji, who has kind enough to provide space of his office and given all necessary help to hold this good function. I also thank learned professor, directors, various colleges and universities, those who have prepared their team and sent them for Moot Court competition and made a successful event of the year. Last but not the least, it is my duty to thank all the students for participation and making this program a successful event for this year. And the students are really very educated and very competent to argue their cases, and they have shown their talent. And I hope that in the future they will become good lawyers as well as judges. Thank you very much. Namaskar.
So thank you, then we may leave.
Thank you, everyone. And once again, congratulations to both the teams, TC 155107, both the teams.
Thank you, everybody. Good evening.
Sabhi ko namaskar. Thank you so much.
Thank you, sir.